Welcome back to the channel and a special bonus video with Mr. Alan Robert Shaw. How are you doing today, Al?
Very, very well. Looking forward to this.
So yeah, me too. So we thought, we discussed it, and we thought that we'd do this extra video because all of the newspapers are talking about new evidence, and of course Amber Heard's spokesperson saying there's new evidence being touted around for this appeal. So we thought we'd talk to you about how new evidence works or doesn't work. You've got to watch to the end of the video to find out in such things, how it works in England and Wales, how it might or might not work in Virginia, but first, a quick look at those headlines, because actually, go back a step. I was drawn in to look at these headlines because of certain discussions, we'll call them, on Twitter, which got quite heated and quite nasty about evidence supposedly coming into this appeal and messages targeted at various different people, and indeed the trial and the jury and everything else, which I thought were quite disparaging and unnecessary and actually quite disrespectful, but by the by. But let's look at these headlines. So some of these headlines, if I can get to the right screen, here we go. So go back a stage. So looking at some of these headlines here, Amber Heard to bringing new evidence to light against Johnny Depp. Another one from E-Online or E-News says Amber Heard says new evidence is now coming to light amid the Johnny Depp appeal. Even Yahoo News pulling up Amber Heard teases new evidence amid Johnny Depp appeal. And of course, all this comes from the spokesperson, which is, of course, put up on IMDb. Amber Heard, and I say it's the spokesperson. It must be the spokesperson. Well, it says it's a spokesperson, but as opposed to a lawyer, because we don't think a lawyer would say that for reasons that we will come to. But let's not get too ahead of ourselves. And let's move, first of all. Al, you might as well talk because you've talked about it before. We've both talked about it, but you can talk for a bit about the England and Wales test, which we refer to as the Ladder-Marshall test when we talk about new evidence for appeals, the general position and what the test is.
Yeah, I mean, it's a tricky one because, I keep using this phrase, which the courts use, the trial is not a dress rehearsal. It is the first and last night of the show. So the idea is you get everything, you get all your ducks in a row, and you go forward with the best case you can. And if you get it wrong, well, it's tough. If you made a tactical decision not to put something in or to leave something out, tough. If you chose not to go exploring down a particular route for evidence, you thought, well, that wasn't a line of inquiry I should have followed. With hindsight, maybe I should have done. Tough. Basically, the court goes, you gave it your best shot. So if you want to appeal, you can only appeal really on errors of law. If you want to try and overturn a finding of fact, that's almost impossible, because if there's any evidence in the case whatsoever, the Court of Appeal will say, we're not interfering with whoever, whether it was a judge or a jury, they saw it all, they're entitled to make their own assessments, it's all down to them, we're not going to second guess them. The only exception to that would be if you could point and say, literally, this is logically inconsistent, there was no evidence of this. Yeah. Every single person in the case said the car was red, the judge or the jury decided the car was blue. That is the standard. So
that's what we'd refer to as an absurdity. If something is absolutely absurd, so they convicted somebody of murder that was, it was a proven fact they weren't even there, for example, just something utterly absurd.
Yeah, a perverse verdict, as they say. I mean, obviously, in criminal trials, you would expect the judge to stop it if something like that, if they thought it should go before a jury. Yeah. In civil cases, and especially when juries say you don't know what the conclusion they're going to come to. But it's very hard to interfere. Now, when it comes to law, even within the law, some laws are, quite clear-cut, very black and white. So, for instance, it could be a situation where, a judge just made a decision that he's just not allowed to. For instance, somebody conceded a point, somebody conceded a point in a case and said, yes, I have no defence to this case, and they still found for them, or something like that. It would have to be that blatant. But even when you have a lot of laws are what we call tests, and I'm setting this up because we're going to come to Ladder-Marshall shortly. And when it's a test, there's a lot of room for judicial discretion. And it doesn't matter that one judge may have come down on one side of the test and another judge come down on the other test. The test for overturning anything on appeal, it's something we call Wednesbury unreasonableness. It's after a case called the Wednesbury Picture House. And the test is that no reasonable person would have come to that conclusion. Not just that most people wouldn't have done, or only a minority of people would have done. It's no reasonable person. So if there's any sort of judges go, well, actually, that was a weird decision that, Lord Justice so-and-so took, but, who knows what's going on in his head? You can't say he couldn't choose to believe that person, or he couldn't have chosen to sort of fall that side of the test. So there's a lot of discretion there, and this is why appeals are very, very hard. But yeah, I don't know if you want to pick up before I actually start going on about Ladd and Marshall.
Yeah, so let's look at it, what the Court of Appeal actually looks at in the first place, and then we can come on to the test for new evidence, at least as far as England and Wales is concerned. So the fundamental principle is that appeals, unless, and this is distinct from, just so we've got any England and Wales viewers that are thinking of appeals from the Magistrates Court to the Crown Court, is different. That is done by a rehearing of the trial, albeit not with the jury, strangely enough. But ordinarily speaking, appealing a decision is not a retrial, it's not a rehearing, it's not retrying the issues and the facts of the case. It's just a review of the lower court's decision. And as Al just said, it's looking at errors of law, sometimes errors of procedure, but that's rare. It's rare, but errors of law, perhaps evidence that was in that shouldn't have been in, evidence that wasn't in that should have been in, and then we might touch briefly on hearsay vis-a-vis the medical notes, Al, as a prompt. But then we look at, well, is there going to be any new evidence in this appeal? Now, as I said, the appeals look at the decision. It's a review of the decision. So if there were to be any new evidence, there's obviously a test for it. There's a legal test for virtually everything. So that brings us nicely into what this test is. If I get the right screen up, it's not that one. There's a test for bringing in evidence. And so in any jurisdiction, this here is our test for England and Wales, which Al, you were going to talk about. We call this the Ladd and Marshall test, or principles with respect to new evidence on appeal.
And has been adopted around the world, although a lot of jurisdictions have sort of come to the same test independently as a sort of convergent evolution. But basically, Ladd and Marshall sets up a three-part test. Okay, so to get some new evidence in, the first thing is, the evidence actually has to be new. And what do we mean by new? It has to be something that either has only just come to light, it's only come into existence. We've got a deathbed confession or something like that, or we found a document behind, a chimney place. Or that you couldn't have found it with reasonable due diligence. And remember, we've spoken about the sort of disclosure procedures we have, which is everybody gives lists of documents and, what evidence they have. So that's the thing you control through. You can take your own investigations, you can speak to witnesses, you can do your own research. That's what you're expected to do. You don't have to go sort of full sort of Hercule Poirot on it or anything, but it's reasonable due diligence. So that's limb one. That's what counts as, quotes, new evidence.
And this is the bit that certainly a lot of cases that have come to me have fallen down on. So I get a lot of cases where a client has said, we've just come out of court, we've got an adverse decision, adverse, of course, being against them in whatever form that might take, but it's against them, and they say, we want to appeal this decision, whether it's civil court, family court, whatever. We've now found the killer email that absolutely kills their case. We were right all along. And the first question, of course, is, well, did you have this email in the first place? Usually, yes. Which, if you had the email all along, you can't just bring it up. Because as this test says here, that if it could have been obtained with reasonable diligence, which is if it's in your own email, it won't cut it. You could have had it, you could have brought it into trial the first time around, you didn't, so it fails on limb one. That's a lot of cases that come to me fail on this principle. And sometimes I dare say it's because they weren't advised properly as to what evidence to bring in. But that, of course, relies on good instructions and honest and full and frank instructions. So, if the client doesn't give the lawyer, the lawyer of first instance, the full story, then the lawyer can't advise, well, you need X, Y, Z evidence. And so, of course, they don't bring X, Y, Z evidence. But then the judge says, well, if you only had this email, then we could have ruled in your favour. But of course, they don't. It fails on limb one.
So that's it. Yeah. So when they talk about this new evidence, you would think if there was something, we would have heard what it is by now. So it's difficult to imagine what it is. Now, if they're just talking about, well, there's, things in the unsealed materials, that's not new evidence. If they are going to argue that some evidence should have been included that was excluded, that's not new evidence. That's what we call, that's a motion in limine, motion on the threshold before we start, and that excludes the evidence. Now, if they were to say, well, actually, that evidence was excluded incorrectly, that's a different thing. That's not new evidence. That's just saying some evidence was ruled inadmissible and it shouldn't have been. And courts can take that into account and go, yes, that evidence should have been allowed in. And then we get on to the second. Then it sort of merges again with the Ladd and Marshall test. So let's assume that it's either past it's genuinely new evidence limb of Ladd and Marshall, or it's actually, yes, this was improperly excluded and should have gone in. That's not enough to get you home. There's the two further hurdles. There's
this being
the evidence. Yeah, I mean, like I say, I'm probably doing the wrong way around because some jurisdictions list them in different orders, but because it's a three-part test.
Indeed. All three have got to be satisfied. So it doesn't matter which way around you do this; they've all got to be satisfied. Yeah,
because the next step is this evidence credible? Okay, if you sort of go, well, I've made down the pub who heard him confess, that might not be enough, or something like that.
That's actually this one here.
Yeah, it doesn't have to be irrefutable. It doesn't have to be, yes, this is rock solid, clear evidence. But it has to be on the face of it credible. And courts tend to apply quite a high test to that, not just, oh, yeah, it could, it's 50-50, it could be either way. It tends to be almost controversial to get. And then the final limb, which some jurisdictions split into two parts, but it must have effectively be evidence that would have made or likely to have made a significant difference to the outcome. If you could pass the first two parts of the test, and go, oh, this is fantastic, and yeah, this is a very credible witness. But so what? If the judge had heard that, the jury had heard that, it wouldn't have made any difference to their decision.
Doesn't make any difference, exactly. And this is an important point because an important influence on the result of the case. It's got to go to an issue in the case, i.e. an issue that was argued in the case. So even if you, as Al, you just said, even if you get some evidence which couldn't have been obtained earlier, it's genuinely new or was wrongly excluded or whatever, on the face of it, credible, but if it doesn't actually go to an issue in the case, therefore it wouldn't have had any influence on the result of the case. And we saw this, as we talked about earlier, Al, with the UK trial then appeal in the Depp and News Group newspapers, because the argument wasn't brought in the lower court because they didn't have the evidence. But then when they got to appeal, they had the evidence, but they couldn't use it because it didn't go to an issue in the case because it wasn't raised in the lower court. So again, that's an important point as to having an influence on the case and the result of the case itself. Yeah,
I mean that was the thing that that they got bumped out in the UK appeal just because they hadn't put it. But so effectively that's the three-part test. Now, one interesting thing is under the US federal rules of evidence, they actually have a fourth limb, which is if it merely goes to credibility of a witness, or they actually phrase it as if it merely goes to impeach a witness, then it doesn't go in. Actually, although it's not explicitly stated, that is probably the same test generally anyway. So if somebody says, well, actually, I put to somebody they were lying about something not relevant to the key issue in the case, and they said they weren't lying, say, for instance, the pledge of donation point. Now we can show that's not true. Courts generally go, well, so what? Because credibility is nearly always an issue in a case. You're always saying, well, the other side, you're not telling the truth. And you will be putting evidence. So the mere fact you now have some different evidence to support a lie, that's always been a rule in federal courts. And technically it's a rule in English and Welsh courts, but we seem to get away with it, which is if you say to somebody, you are a liar, and you sort of to put to them and say, well, to prove you're a liar, isn't it true that you once told a lie in a particular time in the past? And somebody goes, no, I've never done that. And you actually have some evidence to say, yes, they did. You're not actually allowed to put that in. Because the idea is that you end up having so much satellite sort of questioning on collateral issues, as they call them, which is, Well, does it really matter? Because then you're sort of going, well, actually, I have the evidence of that time you lied in the past in a totally unrelated matter. Oh, well, I'll call a witness to say, actually, that's not true. And the person who's telling you that, or that piece of evidence, that's not true. And then, well, I can prove that that person actually is, your witness isn't telling the truth.
And where do you draw the
line?
On,
inception. So the courts have to draw a line somewhere. So you get one chance to put you're a liar. And if they say no, well, that's the end of it.
Sort of it.
Yeah. But that's why I suspect that... because I've got, like I say, I've always said that the appeal court was very harsh on that commission here.
And I'd agree, because it was, because if you take it as in isolation, it was quite an important thing. But
yeah, but I think they should have said, actually, we don't blame you for not putting it, and we're not going to be too harsh on that limb. But it's still not going in, because so what? It's not relevant. That. It was merely about credibility. The judge, although people are quoting that passage a lot about the, prove she's not a gold digger, I don't think it would have made any difference to that judge. This is a judge who didn't care about previous effectively perjury.
Yeah.
We say, well, we've proven that you've lied on an official document. So what? People, and this is the English test. The old test used to be that sort of false in unum, false in omnium. False in one thing, false in everything. That's not the test in a lot of common law jurisdictions. It is in some US states still, but you look at each case in its isolation, and even if you think somebody's lied, you can sort of say, why might they have lied? Is there a good reason for them to have lied in that particular case that doesn't apply in this case? They were embarrassed. They wanted to bolster a good point. It was a very specific set of circumstances. So they do look in isolation. I mean, the whole point of credibility, because there always used to be this idea in English law that you're only on trial for that one very specific thing, whether it's a crime or a civil matter.
It's the issue that's brought into court. Yes, it's exactly how I put it to clients, is to say, well, when you go to court, you're asking the court to make a decision, and it's either on a charge, indictment, or on an issue. And so those new to court or court proceedings, let's say family and civil and so on, will hear the judge refer to what is an issue in the case, and that's something the court has to decide on. So the court's deciding what it has to decide on, and only those things. It's not going to go outside of those remits and go on a hunting mission to see what else it should look at, and it's confined to what was decided in the case. And then as for appeals, how it was decided, and not any new issues, not any new arguments. Even, I mean, interestingly enough, even arguments that were not put in lower courts cannot then be put in the appeal court, because it wasn't an argument. It wasn't put. And as Al, you just said, if it was put and there was an answer to it, and that's it, and decisions been made on it. So then we come back to these headlines: new evidence in appeal. So what we probably didn't say as expressly is new evidence in appeals is very, very rare. It's a very difficult test. It's a very high threshold, and in reality, it's not usually going to happen. And so I think I'll go out on a limb. My opinion, for any defamation lawyers watching, my opinion based on all of that is that this is somewhat misleading, because it just blurts out a headline which a reasonable person would infer that there's going to be new evidence in this appeal, which it's more likely not going to be the case, in our view.
I mean, it could have been, because, that press release said about new evidence. Now, if they were to say new arguments, that still technically wouldn't be completely correct, because they're raising arguments they actually did raise pre-trial.
Previously, yeah.
Not pleasing bar. But, Tease's new approach to case, that might be accurate. But of course, new evidence always, because, like we've said, this is all being played out in the public arena. New evidence, it's your classic TV situation, isn't it? Just one more thing, and Columbus finds a thing, or, that woman who lives in Cabot Cove, which is 86... The murder rate in Cabot Cove is 86 times that of Caracas, which is the most dangerous city on earth. So no wonder Jessica Fletcher was so busy. But yeah, it's new evidence. It makes it exciting. It's like, new revelation. This is all going to turn it. But my guess is that their new evidence is either going to be arguing that some of the motions in limine incorrectly excluded evidence, I think that's got
to be it. It's got to be it. And my view, Al, you can give yours. My view is that doesn't really have a shot. I mean, just taking the therapist notes as one, they're hearsay, and I think that's largely what they're referring to as medical evidence in quotes, which isn't really medical evidence. It's just therapist notes, and a therapist is not there to determine fact, and certainly not a finder of fact in any jurisdictional position whatsoever. A therapist is just there to sit and listen and provide support, and that's all the therapist is going to do. So there it is. That's what we think. But we better get this wrapped up and uploaded because we'll be sending you straight into the live stream, which is at 2 p.m., which is GMT +1 UK time. But in literally a few moments' time, you should hopefully be redirected straight into the live stream. So stay where you are. Al and I, thank you very much for your time and attention, and we'll see you there. Stay tuned.